Hello.
Hi,
Oh, good. I can hear you. You can hear me, I assume.
I can.
Great. Have you debated on call out before?
This is my.
Oh, okay, great. Well, welcome. Um, so this is not a tournament or anything. I'm going to be a little more casual than I would be otherwise, So
Yeah.
my thought, yeah, so that's cool. My thought was this. One of the reasons I did this debate is I thought a lot of people who discuss abortion don't know the Roe v. Wade case very well and know the law surrounding it. So I thought I would start. I don't know your level of experience with it, but I thought I'd start by kind of explaining the case from my point of view, just so that people who are out in the audience have that kind of understanding at a basic level.
Yes. I'm
Okay.
familiar with the case myself, but yeah, feel free.
Okay. And then I'll kind of let you have the first go at a critique of it, and then I'll come back and we'll go back like that.
Okay,
Okay.
great.
So the basics of the case, from a standpoint of the suit, there was a woman by the name of Norma McCorvey, who is Roe. They used a pseudonym during the case. She was pregnant for the third time in 1969. She sought an abortion in Texas, where they had a law against abortions. At first, she sought the abortion under the claim that she'd been raped, but which was not true, and she couldn't prove that case, and later recanted that claim for her lawsuit. So she was denied. She was then encouraged by some civil rights lawyers in the area to file suit under the Ninth Amendment. So the Ninth Amendment of the Constitution and the Bill of Rights says the enumeration in the Constitution of certain rights shall not be construed or denied. Shall not be construed to deny or disparage others retained by the people. So the case in contention was that the right to an abortion was one of these other rights that are not enumerated in the Constitution, yet have some protection. So she won her case in the Texas District Court, but the decision was appealed to the Supreme Court and reached the court in 1970. And it wasn't heard actually until December 1971. That happens a lot with Supreme Court cases, which of course means it was too late to really be meaningful for Norma McCorvey. She went ahead and had the child. In the meantime, the change in justices on the court further caused them to rehear the case in October of 1972. So they had a change out of the people there. So they thought, well, we're going to need to hear the arguments again so the new justices can get a handle on the case. And the judgment was finally issued in 1973. So Norma Roe ultimately did not have an abortion. Her child was put up for adoption. In time, she actually came to regret participating in the lawsuit. She converted to Christianity, and she opposed the decision on religious grounds later and became an advocate for a pro-life position. So let's talk a little bit about what the Supreme Court actually decided. So it was a 7-2 decision. So there were 7 justices that agreed with the decision and signed on to the official document, and 2 that were in dissent of it. So the court found that the Texas law violated Roe's right to privacy, though they did not agree that this was guaranteed, especially by the Ninth Amendment. Now, the right for privacy is pretty widely recognized by the court as an implicit right stemming from the first 5 amendments in the Bill of Rights. It's not explicitly in the Bill of Rights, but it is implied through the idea of individual sovereignty, and a number of the other rights enumerate things that would lead one to sense that people have a personal sphere from which the government is not supposed to intrude. It was first articulated in the late 1800s, right, like around 1890 or so, and acted on by the court around the turn of the century and became a precedent after that. The court then looked at the state of Texas's claims of interest to regulate abortion. That's because even though things are in the Bill of Rights, they're not absolute. The state can infringe upon your rights if they have sufficient warrant. So they're looking at what the state of Texas claims to be the warrant to infringe. So the first was the health of the pregnant woman, so the health of people who are pregnant. And the second is the life of the unborn child. So these are the 2 things that the state of Texas is trying to uphold and protect, and comes into conflict with the right to privacy. So the court applied what's called their strict scrutiny test, which is a test that says that the state has to show a compelling state interest. This is the highest and most restrictive standard that the Supreme Court uses in civil rights cases. It's commonly used for the First Amendment and for a number of other amendments as well. And it really, compelling state interest really means that, like, when you look at the case, there's kind of no question that, yes, indeed, this is something that the state needs to do, and that by making this law, they're really going to have an actual impact on this right that they're trying to protect. And that's the best kind of layman's description I can give for it. So the court deemed that these interests to be legitimate ones, and then so they set about to examine how they could reach the threshold of being compelling in this case, compelling enough to overwrite the right to privacy. So they looked at pregnancy in light of these two interests. They found that in the first trimester of a pregnancy, the potentiality of personhood of the fetus was relatively small. So the state lacked a means of ensuring life. The state can't really protect the unborn child because the unborn child cannot survive on its own. It can't survive without its mother. So it's sort of beyond the reach of the state, and the state, through legislation, doesn't have really a lot of ability to affect that. They also noted that abortion was equally safe as the eventual pregnancy at this stage. So abortion was safe for the mother. So there really wasn't an interest in protecting the life of the mother, the health of the mother during this early period. The abortion was a relatively simple procedure. So they decided that there was not a compelling state interest at that point. Then they looked at the second trimester, and they found that now the state has a compelling interest in the woman's health because it's possible that an abortion could lead to medical complications, or is more likely to, that would be greater than those of carrying the child to term. Thus, there is an interest, a compelling interest for the state to have legislation aimed specifically at protecting the life of the mother. They still haven't decided that because the fetus isn't viable outside the womb, that there is a compelling state interest to protect that life. So they allow for regulation for the health of the mother, but not for the protection of the fetus in the second trimester. By the third trimester, the fetus becomes viable outside of the womb and therefore has independent life of its mother and her kind of jurisdiction, personal jurisdiction, you might say, to some degree. And so they find that the state at that point does have a compelling state interest in the life of the fetus and in protecting it. And so they are allowed to make legislation that seeks to protect that right and is able to override the competing right of privacy for the mother. However, they have to allow for equal weight between the health of the life of the child and the health and the life of the mother. So if carrying to term poses a significant risk to the health or life of the mother, then they couldn't legislate exclusively in favor of the child. They would be kind of balanced interests. And so therefore, while it still would be an interest, it wouldn't be a compelling interest. And so it falls short. So that's, I think, a pretty good summary of the breadth of the case. There's other related issues about jurisdiction and stuff. We can get into them, but they're not critical to what most people are interested in the subject. So at that point, I'll turn it over to you and see what you have to say about it.
Yeah, that was a good summary. So I'm going to just go into some of my critiques after I announce like kind of a little framework. I've got 4 total critiques of the decision. So if you want to go like one by one, would that work?
Yeah, I think that makes for a little bit better debate. But if we start to run over one, just say, let's move to the next, and we'll do that.
Okay. So I'm going to start out with a little bit of like understanding of what makes a wise legal decision. So I'm going to define a wise legal decision as something that was A, correctly decided, and B, established a settled body of law. That's not me talking. That's actually something that Justice Scalia said in his Planned Parenthood v. Casey dissent.
Okay.
And the second point I'd like to make is the idea of legal versus political, which basically is just that we need to be looking at the legal decisions and the legal basis for the law for the decision, not really the political consequences of it. So can you agree with that?
Yeah, I think so.
Okay.
I had, under my wisdom criteria, it was based on law rather than personal opinion, religious views, or emotional appeals. I would agree to add politics in there. That it's weighed carefully and given a great deal of deliberation. It strikes a balance between competing interests rather than simply making a blanket judgment. It's, let's say, nuanced. And that it is based on established constitutional law and precedent, at least for the most part.
All right.
I think we're pretty close.
Yes. So I'm going to go into talking my first argument, which is going to be about the whole right to privacy issue. Now, the problem I have with the whole right to privacy basis, which was used both in Griswold v. Connecticut, the case that legalized the use, or that prohibited states from making illegal the use of contraceptives among married individuals, as well as some other cases, but particularly Roe v. Wade, is that there really isn't a right to privacy within the Constitution, I don't believe. Well, the actual quote described this idea of being penumbras of privacy, which were found on the shadows of the Bill of Rights based on provisions like the First, the Third, the Fourth, and the Fifth Amendments. But the problem with that is that nobody really intended to or put any provisions in the Constitution that had anything to do with sexual privacy. It's kind of a bit like if an officer was going to pull you over and said, you know why I pulled you over? It's because of the speeding fine. And you say, well, I wasn't speeding, officer. And he says, well, no, you weren't speeding, but the whole point of speeding is to keep everybody safe. And that would include people within your car. And what I saw was that you had soap painted across your rear windshield. And that obstructs your vision and makes everybody less safe. So I'm going to cite you on speeding because you had windows covered with soap in your car. That's kind of what I see as an analogy for what the right to privacy is. It's not really there. It's judges making it up, as I see it. I mean, if you want to come, would you like to say something about that?
Sure. Well, I mean, there's a lot of approaches to how legal people, and I'm not a lawyer, I'm just sort of a Supreme Court fan, you might say. So there's a lot of different approaches to how people look at the Constitution. So what you give is what you might call a strict constructionist view, which is to say that the Constitution is definitive, it doesn't have any loose ends, it's not open-ended, and that what it says is what it says, and that's it. And I think there's a couple problems with that. Historically, when you look at the Constitution, it was formed, by a bunch of people coming together to try and make a compromise to get the 13 colonies to work together. And so there were a lot of things they just had to leave open, right? They were like, well, how exactly are we going to elect the president? And, well, we could do it this way, we could do it that way. And there was a lot of arguments back and forth. So and then they were like, well, we'll just more or less leave that to the states. Like the states will figure out how they get electors and the electors will show up and vote. So there were a lot of things they did in the Constitution that are essentially compromises and open-ended doors so that those things could be discussed and figured out later. Because if they didn't get a Constitution together, the whole thing was going to go kaput and the United States wouldn't exist, right? So a lot of compromises were made. The Bill of Rights is one of those compromises. Not a lot of people were like, if we put a Bill of Rights in and we list out some rights, what's going to happen is that means they'll just any other right that we forgot about or we didn't think to include is going to give the government an excuse to come down on us and restrict those freedoms. So they opposed the Bill of Rights. The people who were the most liberal meaning the rights of the individual are paramount in society, right? So the people who are most liberal said the Bill of Rights is a terrible idea. Other people were like, look, if we don't write down at least some of the ones that we can come up with now, there's just too much vagary. Like we really want to nail some of these things down. The Ninth Amendment, although the Supreme Court didn't rule on it, is, however, illustrative of this idea. They were like, but there's rights we have. We can't enumerate them all. We'll be here all day. So let's put something in there that says, right, even though we didn't say some stuff here, there's room to protect it. That doesn't mean the government gets to trample on you. They at least have to justify that they've got this right to do it. The government has a mandate to do something to you to impact your personal sovereignty, as I like to call it, right? So we all have liberalism is about people having individual sovereignty. We give some of it over to the state in order for protection. And the Bill of Rights is about enshrining certain aspects of the sovereignty of the individual. And the Ninth Amendment is about saying, look, it goes beyond what we just listed here, but you guys can figure that out for yourself. So the Supreme Court looked at, various rights. We have the freedom of speech, the freedom to associate, freedom from unreasonable search and seizure. And they looked at these things and they talked about individual sovereignty. And they, illustrated that, look, the basis of all these things is this kind of sovereignty and this idea that there's a personal sphere, a private sphere, and the government should not be interfering with that. And the case that you talk about, Griswold, was really about what married people do in their bedroom. Does the state have the right to dictate to me how I have sex with my wife, and how we do it, and what way we do it, and when we do it, and whether we use contraception or not? And the Supreme Court says, basically, hell no, right? Your marital bond, your private life with your wife and your family is among the more sacred areas of personal sovereignty. And they express this view as the right to privacy. And they point to all the other rights and say, look, these things also, if you think about them, are based on that same idea that the government just can't come into your life and tell you what to do, that there's a personal sphere that they should not intrude on. So I think it's pretty well justified based on the liberal intent of the construction of the Constitution and the fact that the Constitution was intentionally left vague with a lot of open doors because there were things they didn't want to decide. So that's kind of my take on it.
Yeah, I've got a couple of points on that quickly. I think this is an important issue. So my first kind of response to that whole idea is that the Ninth Amendment wasn't intended to be used as a basis for judicial decisions. And that's because while the United States is a common law republic, it wasn't intended to be used as this kind of blank slate for judges to make up, oh, here's this right, I believe, so therefore this has to be protected. That basically leaves it entirely up to the court to add any new right to the Constitution that they wanted to, which clearly goes against the founding intent, which even like the most liberal founders, I mean liberal in the sense of preferring more government power, of course, that's sorry about the confusion there, but even some of the most founders like Alexander Hamilton still recognized that the court was intended to be the least powerful of the branches of government. And my second point about that is kind of it's an entirely different kind of privacy, the ability to do what you want with your body or to do what you want in your bedroom, so to speak, than it is to have somebody, not a police officer, not coming into your house to search your things. Like, it's a completely different area of privacy. It's not what the founding fathers meant. Even if they conceived of this right to privacy, they were talking about the government coming in and searching your stuff or quartering soldiers in your house. That's an entirely different issue from the use of birth control or the right to abortion.
I hear you there. On the Ninth Amendment, of course, the Supreme Court, understanding that it's shaky legal ground to say this is a Ninth Amendment ruling, right? They get that. They didn't do it, right? Because of that reason. It's sort of the no-go zone, right? Because if you use it in that way, the sky's the limit. You can do it. I have the right to stand on my head and, throw spitballs at people. No. So I agree with you there. But what it does do, and what a lot of scholars have argued, is it gives us a window into this general principle that the Bill of Rights is not all the rights that you have, right? And the Ninth Amendment is just there to tell us that we need to consider more than that we need to think beyond just this list. That doesn't mean it's carte blanche, that everything we can think of is protected. We have to do some analysis. We have to do some work to think about it and say, does this seem like a fundamental thing to you or me? So yeah, if somebody comes into my house and they want to rummage through my cupboard or something, right? That's really annoying. I feel like that's an invasion of my privacy, right? And let's say on a scale of 1 to 10, how private I think my kitchen cupboard is, it's a 3, right? Yeah, it's mine. It's my house. I'd rather you don't look at it, right? However, my baby, if I was a woman, my child, what's inside my womb, my reproductive organs, that's a 9 or a 10. It's at the very top. It's like the government wanted to come in and give me a cavity search, just cause. Hell no. You want to look in my handbag? Yeah, okay, sure, that's fine. But if you want to look inside my body and tell me what kind of sex to have, that's a monstrous invasion of my privacy, in my opinion. Different people feel different ways. Some people, when you take $5 from them, they feel like the world has come to end. I don't care if you take $5, but if you want to take a blood sample from me, yeah, screw that. I feel, when you get past my skin, you're really going to an incredibly personal place. And so I think it's very wise to look and say, yeah, these are some really personal subjects that the government should not be mucking around in. And the Ninth Amendment gives us cause to look further for those. But we have to base them on something stronger than just an open-ended door. And that's why, it's people's feelings, and we look at the other amendments and we can see how they're related to that. And this could even be stronger.
Yeah, I understand where you're coming from there. I still don't see any basis of deriving this right to privacy and taking this issue, which is seen very clearly in examples of government searches, you can't quarter soldiers in your house, and taking that just to then saying no state gets to regulate all of these things like contraceptives and abortion. And if you want to move on, I can talk more about,
Sure.
I have some other areas that we can talk
Sounds
about.
good, yeah.
Yeah. So I'm going to actually talk next about the whole idea that abortion is a fundamental right, which is where you start to apply strict scrutiny. Now, the argument I'm going to make here is that abortion actually isn't a fundamental right. And we can look at this by looking back at the history of the issue. Now, so in 1868, when the 14th Amendment was passed, which is how the government gets from, you have this right to privacy, to states can't violate this right to privacy, the due process clause of the 14th Amendment.
Mhm.
30 out of 37 states prohibited abortion. And there wasn't an issue about that until 1973. Now, what I'm saying there is basically that at the time of the passage of the 14th Amendment, most states, most people in the Union did not have access to any kind of legal abortion. So it doesn't appear that there really was a case to be made that the people who wrote the 14th Amendment, the framers of the 14th Amendment, saw that there was going to be this issue of applying the due process clause to abortion. Otherwise, they probably would have said something about it.
Yeah, I mean the 14th Amendment. I have another like debate topic on that one, so I'm kind of a fan.
Yeah,
It
I
was
saw that one.
written in the context of slavery, and the state's desire to, or the North's desire to force the South to accept the civil liberties and rights of African Americans, and it kind of did that a little bit for a little while, and then pretty soon the courts just pretty much ignored it. They used it occasionally to as a rule to kind of slap around some people that had businesses or didn't have businesses, and some economic cases, but it really wasn't used to nail down. In fact, it was the court specifically denied that it was to be used for the purpose to which it was written for, because the court was very conservative in the post-Reconstruction period, and the South. Yeah, more or less when the strong abolitionists were out of Congress, the South ran rampant. We had Jim Crow laws, et cetera, et cetera. It wasn't until much later in the 1960s, around the period that we're talking about, when the civil rights movement took place, and people started to take the issue seriously again. And they looked at the 14th Amendment and said, no, you know what? This was really written here to give African Americans legal rights, and they don't have them. And it's time to put a stop to that. So the courts are always, their job is to interpret the law, and depending on who you have in there, you're going to get a different kind of interpretation. Today, we don't really question that the 14th Amendment protects the rights of African Americans to vote and to be able to be treated as equal citizens. But for many years, that was the case. And right in the same period as Roe versus Wade, we see an expansion of this idea that the 14th Amendment really does grant people all throughout the country civil rights in the full scope of what's protected by the Bill of Rights. So this is part and parcel with that general social movement, one that is very near and dear to my heart, and I think is a great progress in the American legal tradition, and in the entire history of America is about the ideals that we had during the Declaration of Independence and slowly coming to realize them over time against the resistance of social standards. Originally, we the people meant 30 white guys in a room making a decision. Then it meant landed gentry. Then it meant, for a while, it actually included some women and some black people. But then they got rid of that. That's no good anymore. Then it expanded to men. Then it expanded after the Civil War to black men. And then it expanded to women. So there's a progress in the law, a direction that the law has taken over the course of American history, and I think Roe v. Wade is in keeping with that.
Okay, yeah, but my main argument here is really that in order for a fundamental right, in order for a right to be granted the status of a fundamental right, the court has argued in the past that it has to be this across American history. You have to see this broad pattern of protection of that right. Like it has to be held sacred throughout history.
I disagree. And because, otherwise we should say, there was 260 years of slavery. That was a broad tradition in American history. Should we then say that the rights of African Americans are not fundamental? Women didn't get the right to vote until much later. So is their political expression not fundamental because historically we didn't respect it in the same way? I think, I understand that idea, right? But because we're talking about classes of people and a history in America that is about increasing the fulfillment of the idea of liberty and individual liberty, I think it's wrong to look back at tradition and just say, well, people didn't have this right in the past. People didn't complain so much. It wasn't a big deal, so it doesn't really matter. Because our history is about realizing that things matter that people resisted before.
Yeah, I understand what you're saying there. I don't think that's really what the court means when they're talking about a fundamental right, because they're not talking about letting black men have the vote as a fundamental right. They're talking about the idea that you have to have this right prized in American society. So, example, the right to be free, the right to vote, And then you start talking about how that applies to other people, even people who've been historically disenfranchised. So what we really see, my point I'm making is that the right to abortion isn't really a fundamental right that you see prized throughout American history. For the majority of American history, at least since the passage of the 14th Amendment, most people did not have access to legal abortions.
But the basis to me, and there is argument back and forth about it, and they do mention it specifically as a fundamental right, but they do so under the context of the right to privacy, right? That's the sort of overarching right under which they put abortion, and it makes sense to me. And they also talk in the decision about, in some ways they frame it as a doctor's right to be able to prescribe appropriate medical treatment for their patient. So how my health works, like what I choose to do with my life, whether I have children, what procedures I choose to do in order to heal myself or make my life better, is part of that sort of personal right to privacy that the government shouldn't be intruding on, that relationship between the doctor and the patient. It's not abortion specifically, right, that they're after. It's what does abortion fall under this range of personal, private, individual rights?
Well, I find it very interesting given that Justice Blackmun, when he's writing the entire opinion in Roe v. Wade, I believe it's the entire first section of it, is dedicated to arguing that historically abortion is a right. Yeah, so he draws this history as part of his argument that it is a fundamental right. Like when they're talking about a right fundamentally, the court tends to rely on not just ideas like privacy or liberty, but on more specific ideas about the history of abortion in America, for example.
It's true. And I, in preparation for the debate, I didn't read that section. I mean, do you disagree with his analysis?
I disagree with his analysis in some parts, particularly the idea about common law. But specifically his analysis, not necessarily the historical facts he brought up. But I also think he didn't put enough weight on the whole idea that around 1868, when they passed it, most states had made abortion illegal. But I disagree with his ultimate conclusion there.
Yeah. But I suppose you would have to ask how long was it illegal and in what states and in what context. But certainly, when you look at the history of abortion laws in England, going back into the colonial era, in some cases they were there, in some cases they weren't. Usually quickening was often deemed as kind of, the point of time in which, and that happens pretty late in pregnancy.
Well, it happens
at the point at which it's
in. That's what common law says. The common law said for boys it was 40 days into pregnancy, and for girls it was 80 days into pregnancy when they counted it as alive.
Yeah, I'm not sure if that's.
You can check the opinion on that, but I'm pretty sure that's what the opinion actually said.
Mm-hmm. Yeah, and as I recall that he debated back and forth about what kind of standard, in a way that the trimester system was slightly arbitrary, but he had to. And the way I look at it personally is the development of a fetus it's a continuum, right? And at each moment, different things happen. And, when you're going to make law, of course, you can't just say, well, it's a continuum. You have to come up with some sort of justification, because when you look at a very early stage fetus, there's not a lot going on there. Late in the pregnancy, obviously, it's pretty much a baby. So you have to draw some lines somewhere. So they chose this particular framework. And of course, as I'm sure you know, later on, this framework that was in Roe v. Wade got changed, right? And they adopted some new and different standards. But
I actually do have, that's actually my
later point. Okay.
About.
Well, maybe that's a good transition into that then.
Okay, then I'll present my third argument.
Okay.
My third argument is about the actual trimester framework. Now, according to his decision, Judge Rehnquist actually labeled it explicitly as judicial legislation, the whole idea of the trimester framework. And I know you elucidated kind of the basis for the trimester framework. But the problem with that, the problem that it all comes out to is it's, at the end of the day, it's Blackmun saying, here are these lines that I am drawing based on my own judgment that sets out when the state can and can't legislate. It's based on these ideas not of individual cases and controversies that the court has to decide, but on, for all of time going forward, here's this rule. It says, from the first trimester of pregnancy, you can't legislate. Second trimester of pregnancy, you can do to protect the life of the mother. Third trimester of pregnancy, then you get to actually have a compelling interest in protecting the fetus involved. Mm-hmm. And that is, at least from my perspective, as well as many others throughout history, including Justice Rehnquist, judicial legislation at its finest.
It definitely has some elements of that. I think the problem is it's a difficult situation, right?
Yeah.
It's something that we can look at, and again, there's a continuum going on. It's hard to really pin. It's pretty easy to say that, yeah, can the state protect the life of a blastocyst? No, right? Not really, right? Can they protect the life of a 2-week embryo? Definitely not. Can they protect a life of someone who's going to be born in 2 weeks? Yeah, absolutely, right? There's a lot of ways the state could, have to induce, say, well, we got to carry it to term, then we're going to take care of the child, we're going to raise the child, whatever it is. They have an interest they can enact upon. So you got to do something, right? You could wave your hands and say, well, you know what? We're just not going to get involved in something that's complicated. But they felt a moral obligation in order to, because there were rights at stake. There were rights at stake of the woman. There were rights at stake of the unborn child. There's rights at stake of the state's interest. I don't usually call those rights, but they're interests, right? And so there had to be, you can't just ignore any one of those. It wouldn't be just. Wouldn't be just to ignore the state's interest, wouldn't be just to ignore the child, wouldn't be just to ignore the mother. So they tried to find a matrix. And to me, that's a big element of wisdom. When you come into something difficult, you don't just throw up your hands and walk away, which would be the alternate choice. They could simply not rule on it, or they could rule that the state's interest always wins, or the child's interest always wins, or the mother's interest always wins. I don't think that's a wise way to go. I'll acknowledge that there is some conflict there between the values we give for establishing a good body of law and the values of my value of making a nuanced decision and judgment, right? So those are at conflict to some degree.
Yes.
I'll let you talk,
Okay.
Simpson.
Yeah. So my real problem with this whole scenario is that when you have judicial legislation, as it's called here in this case, you're undermining the very purpose of the court. It's overstepping its bounds. So the court is established, in Article 3, Section 2 to decide cases and controversies. And that's great. And so when they're looking at cases and controversies, they have the absolute right to decide the state's interests versus rights of the individual. Nobody's questioning that. But when the court comes out and says, for all time, here is this framework in which states can make decisions. You can do this at this time and this at that time without really a legal basis for what they're doing there, just saying, oh, we judge that generally during this period, you have this problem and we can't really deal with that, so you can't do anything during this period. Then that really is judicial legislation. It's adding rules that aren't based in the law and help to undermine the democratic process, or at least restrict it.
I think it's a little different. I would describe it as guideline for legislation that doesn't run afoul of the constitutional protections. So it's saying, it's not making a law. It's not saying that you can't have an abortion in the third trimester, or that you have to allow women to have abortions in this stage or that stage. It's saying, if you want to make a law, here are the lines that you should not cross if you don't want to cross if you don't want to cross that constitutional line to where you're violating the woman's right to privacy. It's not saying that you have to make these laws or how you should make these laws. It's just setting up some boundaries. Just like when they give an advice on freedom of speech, they'll say, hey, you can't yell fire in a crowded theater. That's not saying that it's illegal to yell fire in a crowded theater. It's saying states can make legitimate laws to prohibit that. However, if they go further than that, if they make a law saying you can't say, boy, this movie sucks, then they're not legislating what you can and cannot say. They are saying, here's where the law protects the right and here's where it doesn't. And so this is the room for legislation, and this is the room where you can't legislate. And of course, it's not set in stone forever. As we know, that the courts did decide that this framework was a little too rigid, and so they came up with a new framework in the future. So it didn't stand up in a sense, and so I'll grant to you it was a little weak. Maybe as a first stab, it was a problem, but still, I think it was a good try, and I don't think it's making a law. It's just setting boundaries.
Yeah. One last comment on that, and then I'm going to go on to my last point.
Okay.
my last comment on that whole issue is that it wasn't really setting guidelines, it was setting prescriptions, in the sense that you're proscribed from making laws in this area. Otherwise, we will strike it down. So that's like a prescription. And a prescription, I believe, is far more legal and is far closer to judicial legislation than you'd see as a guideline on an issue like freedom of speech. So the last argument I have here is that this legal decision, this legal framework of the trimester framework that they made, didn't establish a settled body of law. It was actually, you could say, struck down in KCV Planned Parenthood. Justice O'Connor in that decision basically overruled that framework and established a new standard, which was the undue burden test, which completely threw out this entire framework and said, well, if we have a state, the state can't put an undue burden on a woman's right to choose. And so there wasn't any more acknowledgement of the idea that in the first trimester a state can do this, or in the third trimester a state can do this. It was just completely out the window. You have no right to an undue burden on a woman's right to choose. And interestingly enough, Justice Blackmun joined that decision, which I thought was kind of funny, but
it is a little ironic, perhaps. Although he admittedly struggled when he did Roe v. Wade, in a way, right? He was searching around, and so I can understand him changing his view or maturing over time. I'll partly just concede this one to you, at least partly. I'll comment on it, but it's prima facie that it didn't stand very long, right? It didn't stand the test of time, and the court found a need to do something else. Now, I haven't studied that case as much, so I can't comment on it, I suppose, with as deep a knowledge. But and the undue burden test, to me, from what I understand of it, it lives a little in the vagueness land that makes it kind of a hard one for state legislators to figure out what's an undue burden and what's not an undue burden. And they're always pushing the boundaries, trying to figure out what that is. And their courts, run up to the case, and they're always trying to push. They would like to overturn Roe v. Wade, of course, but first they kind of have to go through the layers, as it were, to get down there. I think it hasn't really established a great body of law either, right? Or led to a really consistent one. And again, I think that's because of the inherent challenge of these conflicts of rights make it really difficult to achieve that in a way that holds up. Especially, I talked about viability, and when I've talked abortion before with people, viability is a moving target. I mean, everybody understands that. As technology gets more advanced, the date at which viability happens becomes earlier and earlier, and thus, Roe v. Wade, or I'm sorry, what was the later case called?
KCV Planned Parenthood.
KCV Planned Parenthood, yeah, or that case becomes a little bit of a moving target, and that worries people who are abortion rights people. They're like, well, maybe we don't like this viability thing because that's like a ticking clock counting backwards to the day we can raise babies in a test tube, right? And then maybe at that point, there's no more. They lose what they consider still other portions of this right to privacy. So I think there's something to that. I guess is all I'm saying. It's a complicated issue, and it is a changing target to which the courts at any one point in time would never be able to fully encompass a body of law that will carry forward forever, unless they were to try and establish, I guess, guiding principles. And that's something, they're a little reluctant to do, because they just want to say, this is what the law is, this is what the law isn't. As of this date and time that we're making this judgment, this is the thing. And I know the court always likes to have perpetuity, but if you look back at the history of the Supreme Court, some of their decisions have lasted pretty much the whole time, but a fair number of them get jumbled about as times change and as attitudes change and understandings change. So I guess that's all I have to say on that.
Yeah, so my point to bring that up is just to say that I don't believe Roe has been successful in wisely developing a settled body of law. Because the central legal holding of Roe, the idea that this trimester framework was overturned later, 19 years later, because it just didn't work. And so now we have a completely different body of law than Roe. The remainder from Roe, the lesson we have from Roe, is not what they intended in the sense of, here's what you can regulate. It's just the idea that abortion is something that's protected by the Constitution.
I would say that, for me, and,
Uh-huh.
legal scholars are going to take different takes on it, of course, but my take is that the real core, the heart of Roe v. Wade is the balancing of those three interests: the state's interests, privacy interests of Roe, and the interests of the child, which is part of the state's rights. But I like to think of it as kind of three different things. And saying that, look, all of these are legitimate, and there has to be a way that we can balance them. And balancing them is best done by looking at the points in time in pregnancy in which there's a legitimate reason to have this legislation, right? Not to just sort of arbitrarily take one over the other. And that basic idea and the idea that abortion, that medical procedures that a woman would have, and choosing what kind of family you're going to have, are part of the sphere of privacy. So those two things are kind of what carried forward, and those did survive into later rulings by the Supreme Court, even if the specific points in time that they chose didn't make it. But the principle under which that was done, that balancing, and the undue burden test is kind of just a more general way of saying,
Yeah.
look, the state does have an interest in trying to protect health of various things, but it can't cross a certain line. Once it becomes oppressive to the mother's privacy, then you have to stop. And where exactly that is, well, that gets argued out in the Supreme Court fairly often.
Yeah, really at the end of the day, and as we're coming to the end of this whole debate, I end up leaving with this whole idea that Roe v. Wade wasn't a wise legal decision, because I don't see that there's a right to privacy based in the Constitution. I don't think that abortion really has a fundamental right rooted in American history. And when you look at the legal holding of Roe, as opposed to just what I've just seen described as the symbolic holding of Roe, the legal holding of Roe was, first of all, I believe, overstepping the court's boundaries. And secondly, it didn't last. It didn't manage to establish a settled body of law. And so just based on those two criteria that Justice Scalia lays out, I don't think that we can consider Roe v. Wade a wise legal judgment.
Yeah, I think that's a fair summary. I would say, on the other hand, that the right to privacy is in keeping with the spirit of the Constitution and the liberalism of the Founding Fathers, and that the way it's expressed is good because it protects fundamental privacy. That when it came to this conflict of interests, in which there are three very legitimate reasons to consider legislation, they struck a careful balance between them that's in keeping with the spirit of liberty, but also the interest of the state in protecting the lives and safety of its citizens. And ultimately, I think those are the hard decisions that government has to make, is balancing our individual rights and the government's action in order to protect its citizenry. So I think it was a great debate. We probably leave it close to there, and I'll give you the final word. That's tradition for the con. But I just want to say I didn't necessarily expect with this topic to get somebody who understood the law really well in these areas. You clearly do, so that was great. I think you probably have a little bit more knowledge than I do.
I don't know about that.
Okay, all right.
I'm guessing you've been around for a little less time than you have. So
that's true. Yeah. I may have a wider range of experience. Yeah, that's very true. But I was really impressed and enjoyed discussing with you a lot. Gave me a good challenge.
Yeah. It was also enjoyable for me. And congrats on your win, by the way.
Oh, thank you very much.
Last tournament.
Yeah.
But really, I believe that Roe v. Wade was it was definitely a hard decision. And I'm going to give Justice Blackmun and all the justices who joined in that credit for making a tough choice. But I don't believe they made the right choice. Because based on the law, I think they kind of developed out of nowhere, and I'll give them some credit for relying on precedent, but still it was developed out of nowhere, this whole idea of a right to privacy. And so you derive from just about the judicial ideas of, here's the general spirit of the Constitution, this whole concept of privacy, and then they apply it to the idea of abortion. And I don't believe that was the correct decision. I don't believe they actually made the right decision in applying this whole idea to abortion specifically. And in addition, when you see what they actually did, we see that, first of all, they overstepped their boundaries, and secondly, that they didn't manage to establish a settled body of law. So although it was a hard decision and not necessarily a position I want to take, a position of any of those justices I want to take, I don't believe they made the correct decision. And so in the future, we need to be looking to how to remedy that